Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman, my law partner. David, welcome.
Much, Michael. Thank you.
So I got some comment from somebody who said that you guys, that means you and me, we talked on this program about prosecutorial discretion. That is the memo that was announced by President Obama, under which they, first of all, they prioritized that what is the priority of getting people removed or deportation or arrested or whatever, which they started something like terrorists and criminals and all that, and David will explain more as to what kind of people are not really a priority and they shouldn't bother and arrest them. And they say that but we still see when my neighbor, my friend or my relative, they did do nothing innocent, just arrested him and try put him in deportation proceedings. So is it true that this policy is not being strictly followed by the ICE people or even the immigration judges? When I am saying immigration judges, when ICE arrests people, most of the time they will put the case before an immigration judge. But there is a guidance even for the judges, how they should treat the priorities, how they should also look at the pending cases or the new cases, because some judges follow. If a person has got an immigrant visa petition filed and he is just waiting for a visa number to become available, the case comes before the judge and the lawyer for the client says that judge, this is another 6 months, 1 year, he is going to get poor money, he is married, he has got a wife, he is a green card holder or something, and these are the priorities of President Obama. He'll say, yeah, okay, fine, put down this case for 1 year down, or administratively just close it, and when we'll see when the time comes in. So from what I see here, David, first of all, I'm going to explain you a little more details about what the prosecutorial discretion memo is, but I'm saying that yes, that happens, and I think our Immigration Lawyers Association also is looking, and we are looking, and people are bringing to their attention that you should be following that. And I believe that there is an issue also. Some of the immigration people say, but this is the law, we have to follow, and you talk more about this. I can also make some comments. So basically what I am trying to request you to give detailed information about the memo, and then to see what may happen, because some people are taking a position, the Republicans especially, that you can't do that. This is the law, you have to follow the law, execute, enforcement. Right. Obama says, so does Obama has authority also? They are even challenging the authority of President. How can he stop what it says the law that illegal aliens, people who committed crimes, they must be arrested and deported? Why are the judges not following it? Why is the ICE not following it? David Nachman.
Okay. No pressure. No pressure. So what Michael is talking about is a memorandum that was issued in late November. It's actually November 20th or 21st. And the memorandum is available online if you'd like to read it. It's called the Presidents PEP program. PEP stands for Priority Enforcement Program. And what the Priority Enforcement Program did was it further enhanced or honed the original letters that had come out. It was actually a further enhancement of the John Morten memo, the Morten
Right.
memorandum. What the Morten memorandum did, and we've discussed it a couple of times on our shows, but I think what we should do is maybe take a historical look at what this whole concept is about priorities and discretion. And it's important to understand that what happened was Julie Myers, who was the John Morton's predecessor, had set out that the government realized that they had limited capabilities to remove people. And what happened was that what they needed to do is they needed to hone in or focus on people who are priorities. And they further stated that there were certain people who are not priorities. So what the Morten memorandum did is it took off from what Julie Myers said, and it specifically laid out clearly where there were not priorities. So people who are not priorities would be individuals who were foreign nationals who are in the military, who may be illegally in the United States, people who are in the United States who are taking care of individuals who are elderly, people with health problems, and so on. And there was also an allusion in the John Morten memorandum to individuals who were dreamers, folks who, for all intents and purposes, were Americans, brought up in the United States, went to school, and thought that they were Americans. And of course, then what ended up happening is the Morten memorandum was further honed by by the president when he made the announcement back in 2012 of DACA, the Deferred Action for Childhood Arrivals program. That was the original DACA program. So there was no challenge, of course, by anyone to that program, and DACA took off, and that was the program that was created for dreamers. And interestingly, what the court has focused on now in the Fifth Circuit, in their consideration of the challenges that were made against these programs, what they've said is, well, why wasn't the original DACA program challenged? Because that wasn't challenged, so why all of a sudden now are we challenging DAPA and DACA, and yet when the original DACA program came in, there was no challenge to it. So that's a very interesting argument. In fact, if I were the judge in the Fifth Circuit, I would probably grab onto that and say waiver. There was a waiver that nobody challenged the original DACA program, and therefore, why should you be challenging the new DACA program and DAPA program? But again, I'm not the judge, so I'm not going to go there.
No, having said that, we are not saying that either the ICE or the judges or the prosecutors are not following the memorandum. My understanding is actually in a lot of cases they are. They are. It's not that they don't look at that at all.
No, I think the programs, yeah, the priority memorandum is followed. The question becomes, at what levels are they followed?
Exactly.
That's really what it is, because, and I think that that's probably the point that Michael's trying to make, is that just because there's a memorandum out there which gives guidance, what is the actual practice? And those sometimes are two different things. So you could have a memorandum where a person is supposed to not be a priority, but you might have an exuberant officer at the port of entry who decides that the individual is a priority, and that's where unfortunately the number one, you have a discretionary issue, but number two is does the individual have the right to do that? But we have, of course, lawyers in the office who always pull out that memorandum and will stand in front of the judge and say, look, Your Honor, sorry, but this individual is not a priority, and therefore they should be let go. You should close this case and focus your efforts on individuals who are priorities. Again, deport felons and not deport families.
So the official, somebody like that, as you mentioned, an officer looks at this way. This is the law. I'm an enforcement officer. My duties are to enforce the law. I believe that this person should be deported or removed or not admitted.
I believe. Discretion.
I believe. Yeah, discretion. He says it is. What is this memo you are saying? Discretional? It's not discretion, right? So I have the discretion, and I'm exercising my discretion, and I believe this is the action that I'm taking is right. And Republicans are following that. Republicans are pushing them, also the immigration people and all that you should be following the law, and not the memos issued by the President Obama, who has no right to issue these memos in the first place.
Right, but remember that, again, if there was such a big hoopla and such a concern over changing the focus of enforcement, then why didn't this litigation erupt back when Morten passed his memo? Why didn't this litigation erupt when DACA was first passed in 2012, when the president made the announcement about DACA in 2012? Why then is there no litigation? Then all of a sudden, now there's a big hoopla. I think that the reason for it is because all of a sudden now, potentially, the individuals in the United States who stand to benefit are close to 6 million people. So now you're talking about significant numbers. And before, you didn't have significant numbers. And that's why everything got swept under the carpet. Now, all of a sudden, it's becoming much more of a concern because many more people are potentially there to benefit from these, from the way this might go.
See, it is the heat between the Democrats and politics, in another way. The politics have been also increasing. With this, what has been happening, they get more and more upset, and the election times are coming. So this is the pure politics. Republicans think by taking this strong position against Obama and on the immigration bill, we are going to get more votes from the people that are conservative. Right?
Well, Michael, you're hitting the nail right on the head, and that is that immigration has always been a political football, always politically driven, And if you take a look at the naturalization, in fact, one of the announcements that the president made in November had to do with the fact that he was liberalizing naturalization. Now, why would a Democratic president liberalize the ability of people to apply for naturalization? The reason for it, of course, is because they know that generally speaking, and this is something from political science, generally speaking, individuals who are new Americans tend to vote Democratic.
Yeah.
So if you're a Democratic president, what are you going to do? You're going to liberalize the rules and allow individuals to come in to vote, and that's why there are rules in place or guidance in place to help liberalize the ability for people to naturalize and to become voting members of society.
One small question that comes from people, we did do a program on Nunc pro Tunc motions, and we explained what Nunc pro Tunc is. And typically what is happening in the type of cases where a citizen filed for a brother petition maybe many years ago, and then he moved on from one address to the other. Immigration Service was not satisfied, they want additional documents information. They send an RFE, request for further evidence to the person, okay, this birth certificate is missing or that's missing and that's missing. But that letter went to the old address, he never got it. And this guy is sleeping also. Basically, some other people think it automatically works. I file a petition and they'll get a green card. They don't understand there's a process. First petition has to be approved, National Visa Center has to complete and all that. So years down the road, all of a sudden they go on the computer, check the status, it says your case was denied in 2010. And they keep running, denied, why denied, what happened, what happened, what happened? Then we find out what happened is change the address and never advise the Immigration Service about the change of address. Immigration Service continued to contacting them on the old address, that's what the last known address they had, and they never got. So this problem is some very difficult, but we have been with all our experience and all that been very helpful in finding a solution, and the solution has been Nunc pro Tunc, means at the time when they denied, they gave them 30 days to appeal our motion, and that time is long ago gone. So what we are saying that okay, but in this motion, Nunc pro Tunc motion, if we give them all the document information, now it is at the discretion, it is possible that they may reopen the denial case and approve it. And but what we do, yeah.
Nunc pro Tunc is a very powerful tool that we use. It's a very powerful tool that we use. It means in Latin now for then, and what it means essentially is that we're able to get the officers to focus and go back to make a determination which they should have made back when, and they didn't properly make it. Now, of course, Nunc pro Tunc is discretionary also, and the officer does not have to grant Nunc pro Tunc.
And there's no appeal against that.
And correct. There's no appeal. You can make a motion and maybe get another officer to look at the basis for the Nunc pro Tunc. But bottom line is, it's all about the equities.
Correct.
So when you're making a Nunc pro Tunc argument, if you can show very strong equities, you can get the officer to buy into the fact that they should go back and they should give the benefit going back. And it's really nice. It's like I said before, it's a powerful tool because it eradicates problems going all the way back to when the case should have originally been granted.
And the last piece of advice is, if you are moving from your present home to another place, you must immediately advise the Immigration Service so that they know where to send you the approval notices or any requests.
And how do individuals? We should tell the viewers how they do that.
Two things
to do, exactly. So.
AR11 is a form that you have to file, and the immigration office where the petition was filed also should be notified about the change of address.
Exactly, and you do that by picking up the phone, calling the 1-800 number, getting someone on the phone, explaining that you filed the AR11 form, which is a very easy form to fill out. You can do it on your own. You don't need a lawyer to do it, and just report to that officer that they should be on the lookout for the change of address.
And if you are in that kind of a situation where you think your Nunc pro Tunc motion may help you, feel free to contact us, and we will be more than happy to look at your matter and try to help you. Thank you very much.
I just want to quickly remind everyone that May 26th is coming up. For those of you who have H-4s, you may be able to apply for employment authorization documents. I would encourage you to take a look online if you have any questions, or feel free to reach out for us if we can answer any questions. But don't miss the opportunity to apply for your employment authorization.